Thank you, Mr. Chairman, and I must say I share the Chair's skepticism about this whole idea. I appreciate the testimony of Mr. Howard Greenspeck and would simply note what he said at the outset. He's here on behalf of an agency giving us data and analysis. And I think the testimony is very compelling about how wrong and mistaken government can be over time. The testimony indicates that this RFS was based on an inaccurate premise, that the projections were wrong. RFS compliance is now going to cost a lot more than it was expected to be. On page 5 of Mr. Greenspeck's testimony, it said earlier projections of growth were inaccurate. Actual and projected reliance on all imports was lower, and so I would simply submit that it's pretty compelling testimony that we surely are capable of getting it wrong here in the United States. Mrs. McCabe, let me just use my remaining 4 minutes to make this one point about small refiners and hardship exemptions. I have several small refiners in my state who are concerned about the impact of the renewable fuel standard on their business and their ability to create jobs and support the families in their area. Small refiners are concerned that RFS, as it exists, has created an economically untenable situation for many companies. In the original RFS rule, EPA encouraged qualified small refiners to seek a hardship exemption. EPA said this would appropriately address the needs of affected parties. However, EPA has begun to phase out hardship relief without receiving feedback from small refineries, without public notice and comment, and without revising the regulation that articulates the hardship standard. I ask unanimous consent, Mr. Chairman, that the following letter be submitted for the record. It refers to a company, the Hunt Southland Refining Company in Mississippi, that has twice petitioned for hardship exemption but has heard nothing from EPA. If this company is unable to obtain such an exemption, many of its well-paying jobs will be put at risk. On page 2 of the letter, the author of the letter points out, they say to me as a senator, they hope that I and my colleagues will consider the following actions. Review with the EPA its rule and the disproportionate impact it has on small refineries. Number 2, insist EPA utilize appropriate standards as articulated by Congress for hardship waivers. And 3, review with EPA the correct parties who should be obligated for compliance under the renewable fuel standard. So in the minute and a half we have left, Ms. McCabe, what about this? What about the seeming change in direction where the hardship exemption was encouraged at first, and then we've had a hard time getting a follow-through?
Well, thank you for the question, Senator Wicker. And respectfully, I would describe it a little bit differently. When Congress passed the law, they exempted small refiners through 2011, and the law then sets up a process for EPA to consider hardship waivers in consultation with the Department of Energy, who has established, after an intensive study of this issue, a set of metrics that they evaluate for every hardship petition we receive. We take these incredibly seriously. These are very serious petitions that we get from people, and we need to make sure that we are consulting with DOE, we are looking at those metrics, we are being fair. This is a competitive issue, and in the last year that for which we issued waivers, which was 2013, we got, I think, 13 waivers, and we granted half of them and denied half of them. And those reflect a very serious, very fact-based inquiry into each petition. So I would not at all say that we have taken a position that we are phasing out those waivers. We take every one of them very, very seriously, and we'll grant them if appropriate.
And I would simply point out that what I'm hearing is that there are companies that have applied and received no answer at all. So I hope
yes.
you'll address that.
The reason for that is that we need to know the final volumes before we can actually evaluate the petitions. And so once we finalize the rule in November of 2015, nobody's compliance obligations began until that rule was finalized. So as soon as that rule was finalized, we began reviewing those petitions that were pending.